Start. It is contended that the board of the GDA approved the proposal on 17/10/2014. Meanwhile, by a letter dated 9/10/2014, the vice chairman forwarded the recommendation to the state government for taking a decision regarding imposition of infrastructure surcharge and corner charge. The GDA published a brochure for auction of plots of land in the developed schemes for purpose of group housing and other commercial purposes. It was clearly mentioned in that brochure that the matter with regard to the infrastructure surcharge was referred to the state government, and in case the state government decided to realize the same, then it would be payable by the allottees. There was no clause for releasing corner charge from the allottees. The petitioner constructed flats as per the norms and sanctioned map, and a completion certificate was issued by the GDA on 22/8/2019. The petitioner paid the entire installments, and there is nothing due to the GDA from the petitioner. It is stated that the petitioner, after completion of construction, has sold more than 80% of the flats to the allottees, but since no sale deed has yet been executed by the GDA in favor of the petitioner is not in a position to execute sale deeds in favor of the flat buyers, who all have made full and final payment to the petitioner. By means of a demand notice dated 10/10/2019, the petitioner has been asked to deposit a sum of rupees 14 lakh towards corner charge, infrastructure charge, lease rent, and freehold charge. The petitioner thereafter that an audit objection was raised regarding the infrastructure surcharge, and as such, the demand notice was raised by the GDA. It is further stated that in 2014, after the GDA requested the state government for amending the provisions of the first government order, the state government issued another government order dated 26/7/2018, by which the clauses for imposition of infrastructure surcharge and corner charge were removed by the government. It is contended that once the first government order was rescinded by means of the second government order, there was no occasion for the GDA to realize infrastructure surcharge and corner charge from the petitioner. It is stated that the petitioner has already paid the lease rent and freehold charges, and hence demanding additional lease rent and freehold charges is illegal. Learned counsel for the petitioner has referred to the judgment of this court in the matter of Virendra Kumar Tyagi versus Ghaziabad Development Authority to contend that in a similar matter with regard to payment of mutation charges imposed under the provisions of Section 2 of Section 15 of the Uttar Pradesh Urban Planning and Development Act 1973. This court held that the demand for mutation charges pursuant to a government order is illegal and without authority of law, and the demand was quashed. It is further stated that the judgment of Virendra Kumar Tyagi Supra was relied upon by the coordinate bench of this court in writ C number 4696 of 2015, Mahesh Chandra Agarwal versus State of UP and others, and a similar demand issued by a development authority with regard to mutation charges was set aside. Challenge to these judgments before the Supreme Court was negated by dismissal. It is stated that it was on the basis of assurance of the GDA as appearing in the brochure did the petitioner agree to bid for and purchase the plot in question, and the agreement to sell Annexure 7 to the writ petition was executed. It is stated that the impugned demand notice dated 10/10/2019 is for a sum of rupees 14 lakh, which includes 10% corner charge, 10% infrastructure charge, and 12% lease rent and freehold charge. This demand clubs all the alleged dues together and no break-up of the charges has been given. Learned Counsel urged that the court apply the rule of in the interpretation of the second government order and interpret it as rescinding the first government order in light of the resolution and recommendation of the GDA, and thus no infrastructure surcharge and corner charge be levied after the issuance of the second government order. In this regard, the learned counsel for the petitioner relied upon a judgment of the Supreme Court. No counter affidavit has been filed by the respondent number 1, state government. A counter affidavit has been filed on behalf of the respondent numbers 2 to 4, GDA and its authorities. It is admitted that the petitioner, being the highest bidder, has paid the total amount towards the plot in question, which was rupees 59 lakh. Apart from the aforesaid, 12% lease rent and freehold charges amounting to rupees 7 lakh was also deposited by the petitioner. It has been stated that the allotment letter was indicated the fact that if the state government directs charging of the infrastructure surcharge, then the allottees would be liable to pay the same. It is stated that when a local audit was conducted by the GDA in the year 2013-14, objections were raised in two matters regarding non-charging of infrastructure surcharge in view of the first government order, though objections raised by the audit department were duly replied, but the audit department was not satisfied with the reply. Thereafter, a review meeting was conducted under the chairmanship of the Principal Secretary, Housing, Government of UP, wherein directions were issued to the effect that in respect of those properties, plots which have been allotted during the period from 15/1/1998 to 26/7/2018, notice should be issued to the allottees concerned for recovery of infrastructure surcharge. It is stated that the notice dated 10/10/2019 is in consonance with the first government order as per the terms of the brochure itself, since the government has taken a decision. The infrastructure surcharge is liable to be paid by the petitioner, since the allotment of the plots were made on as is, where is basis, and as such, the corner charge is levied only on those plots which were situated in a corner. The plot of the petitioner is situated on a corner, hence the petitioner is required to pay the corner charges also. It is stated that under the direction of the government on the amount of the infrastructure surcharge and the corner charge, additional 12% towards lease, rent and freehold charge were also payable, and as such the demand was incorporated in the letter dated 10/10/2019